Okay, so hi everybody. It is Thursday, June 25th. It is 1 p.m. instead of noon, as we've been doing this all week, Eastern Standard Time. I am Kate Klonick. This is everything you needed to know about Section 230 in 5 hours, hosted by the LISP. I've had to have a Twitter notification label attached to the start of this thing about misinformation, because yes, I am aware that it is not, in fact, going to be 5 hours total. It's going to be 7.5. But I think that the general conceit of the series is basically to have people talk about Section 230 over their lunch hour, get us all kind of expressing the different perspectives that we have, whether it be from telecom or agencies, or from plaintiffs' attorneys, or from free speech advocates, to kind of understand why we are talking about Section 230 right now, and why there is so much going on in the courts and in DC around Section 230 at the moment. So in the last, just to kind of give an overview of what we've done for the last couple of days, we had the history of Section 230 on Monday. And then the next day we had some amazing speakers, legal academics come in and talk about what Section 230 means for telecom and agencies as contrasted to the civil liability aspect that we had talked about on Monday. Then on Wednesday was the what 230 meant for platforms, and we had former general counsel at Twitter and at Google and the head of content policy at Facebook all speak to how Section 230 played a role in the formation of their company and how they set their internal and external policies. And then today we're going to kind of pivot and take this to the current day and talk about why we're talking about Section 230 and why we're talking about it now. And so today with us, we have Carrie Goldberg. She's an attorney and founding partner of CA Goldberg PLLC, and a plaintiff's attorney for many people that are trying to go after big tech for some of the harms they cause. David French, an attorney and a senior editor at The Dispatch. And we have Cathy Gellis, an attorney and technology policy outside counsel based in San Francisco. So thank you guys so much for coming on the show today. I will just give the audience and everyone else a brief kind of overview of what the format will be like. We're going to do about 45 minutes of me moderating a conversation between everyone. And then we're going to open it up around 1:45 and talk and take Q&A questions. I have been bringing in voice only people to ask their questions live, just so that we have them on the record. But if you're not comfortable with that and would prefer me to read your question, please note that in the Q&A. I won't be taking questions in the chat. I will only be taking them in the Q&A because there's just too many things going on all at once. But with that, I think that we're kind of teed up for our conversation. So I kind of want to start with yesterday. Because we had this very interesting, I mean, it couldn't have been more perfect in my opinion, of like, we're doing this week-long webinar and like a Section 230 reform bill, bipartisan reform bill gets dropped right in the middle of like the week. I was like, I have the best news sense. I don't really have the best news sense. I just like, this is, people will not shut up about this, about Section 230 right now. So I don't know, like, David, have you gotten a chance to look at the PACT Act yet? Is that something that's on your radar? And then, you know, if anyone else just wants to like weigh in, just kind of raise your hand, and I will unmute you and stuff.
I have not had a chance to dissect that bill. I've been focused more on the bills that have come from the right, for example, the Hawley bill, reform bills that are specifically engaged with political speech, which is mostly where folks who are conservative are concerned about Section 230 is in the political speech arena. Are there different standards applied to conservative speech versus progressive speech online? And so that's where I've really focused a lot of my attention from the standpoint of defending Section 230 from that effort to introduce government supervision into the regulation of political speech in social media. And my position has really been pretty simple on these lines. I mean, it's kind of twofold. One, that a private corporation has the ability to create the kind of community that it wants to create. So if Facebook and wants to be sort of a more family-friendly kind of platform in the sense that it's going to prohibit nudity or pornographic images or images of grotesque violence, but it's also going to be more freewheeling on its political speech, that's completely a decision that Facebook can make. If Twitter wants to be more edgy on some of the violent or more risque content, but wants to be more, create a more progressive space on political discourse, that's something that Twitter can do. It's a classic aspect of, it's a classic exercise of First Amendment rights by these corporations. And that what Section 230 does, secondly, is really as a common sense way, puts into the virtual world a lot of the principles that we think of in the real world. So for example, I don't know if you guys saw the viral video that went around of yesterday online of this Palm Beach City Council meeting where some people were talking about masking orders and raising like all kinds of conspiracy theories to the Palm Beach City Council. And you know, one of the things that is we've long recognized, for example, if I'm going up to a microphone at the Palm Beach City Council has provided the microphone and the platform, and there's a TV camera focusing, maybe going out on local public access TV. But if I get up there in front of the Palm Beach City Council and talk about chemtrails, or I talk about some of the wilder conspiracy theories like 5G or the Gates vaccine or whatever you've seen, some of the wilder conspiracy theories, nobody thinks that's Palm Beach City Council speech. That's my speech. And if the Palm Beach City Council says, hey, wait, we don't want you to curse, or we're not going to allow you to personally insult one of our city council members and cuts off my microphone, that doesn't make what I just said the Palm Beach City Council speech. And so this is something that I think really reflects how Section 230 reflects how we understand who is the speaker in the real world, and how people who provide forums for communication don't suddenly also become the speaker when they put limits on how others may participate in that forum. And that's all common sense. And that's where I'm coming from in this debate.
Yeah, I think you're an outlier from a lot of social conservatives, David. I think that,
Yes.
like, right now you have, so do you want to kind of state like why social conservatives like Hawley are coming? I mean, I think that you kind of have this, you know, we've talked about this, you have this role of kind of speaking to social conservatives and kind of that are all trying to kind of come after 230, but can you kind of speak to why Hawley is passing this right now? Just the general idea of the social media bias and things like that.
Yeah, so there's a lot of fear on the part, especially of social conservatives, that says these corporations are run by people who disagree with us. And in many cases, they're run by people who don't just disagree with us. They might really outright hate our point of view. And this social media company is also, at the same time, my primary method of communicating to the world. So if I'm a social conservative activist and I have 300,000 Twitter followers or whatever, Twitter is and I have invested countless hours and time and energy and effort into building this platform, and it's run by people who strongly disagree with me and maybe might even loathe me. I'm really worried. And then you have the anecdotes of this person who was temporarily suspended from Twitter because of Twitter didn't like their pronoun usage in a debate over transgender issues, or this person who was suspended for a threat when someone on the left made equivalently threatening speech that didn't receive a suspension, or the president has had some of his tweets hidden. And so a lot of people feel like the sword of Damocles is hanging over their head. I don't trust these people to preserve my access to the public. And I get that. I mean, I get that. The problem is they're then taking another step, which is then what I want the government to do is to protect me from these people. And that's where we we strongly break. I think as a matter of constitutional principle, it's wrong. As a matter of pragmatics, it's wrong, because, you know, if you are, say, a strong MAGA voice on Twitter, and let's just imagine for the sake of argument that Trump loses in 2020. Well, then if regulation of political speech on large social media companies has been delegated to a government commission, are you sure you're better off when Joe Biden selected the commission? Are you sure about that? And so, you know, there seems to be this notion with a lot of these drives to control these companies. Well, you better be sure that you're going to be in charge of the government indefinitely if you're going to place the government in that much control and place it in the driver's seat. So as a matter of constitutional principle, I reject that appeal to the government. And as a matter of pragmatics, I think it's short-sighted. I'm having trouble hearing you, Kate.
Oh, there we go. Sorry, small technical issue.
Yeah.
I've been doing this for all week and I still am screwing it up. I think that was a wonderful summary, David. Thank you so much. What I think is kind of fascinating about 230, what I sometimes talk to reporters about, is that there's this very interesting kind of set of political motivations where you have people who are very far on the right and people who are very far on the left finding each other in agreement for totally different reasons, about why we want Section 230 reform. And so we've now that was a wonderful survey of kind of what's happening and what people on the right are thinking. But Carrie, you have represented a lot of people that have been harmed by tech companies, or who other people have I wouldn't say maybe not harmed by tech companies, but that tech companies have maybe exacerbated the harms or helped perpetuate the harms to your clients, and been stymied by Section 230. And so you have become kind of a staunch advocate for Section 230 reform or abolishment. Just kind of tell us a little about your perspective, and then you want to talk a little bit about the Herrick v. Grinder case that you had.
I don't even know if I'm coming at this from a left perspective or a right perspective. I'm coming at it from the perspective that if you've been injured by somebody or by a company, then you deserve the right under our judicial system for recompense and for justice. And if there's an entire sector of industry, the most powerful, wealthy industry in the history of the universe, that is outside the reach of the courts when they cause injury or they aid and abet injury, then that's a real problem, and that's an access to justice issue. And we don't see that in any other industry. So, it's creating a real sort of market distortion problem, and it's perpetuating this idea that these companies are sovereign. They're our judicial system has no control over them. They just keep getting powerful, and it makes them be able to grow that much faster without any restrictions, without any sort of the pressure that we see in other industries to be creating safe products or to be thinking about how their clients and their users and their customers could be injured if they make bad decisions. There's no pressure. And so as a result, my law firm is flooded with people whose lives have been completely overturned by stuff that's happened to them on the internet. And no, I'm not talking about defamation or a bunch of Twitter trolls calling somebody a bitch. I'm talking about my client Matthew Herrick, for instance, who was back in 2016. He was a 33-year-old waiter in Manhattan who had just left an abusive relationship. And his ex-boyfriend created profiles in Matthew's name with Matthew's pictures, saying that on the gay dating app Grindr, and he then would direct strangers to Matthew's home. The profiles would have pictures of Matthew saying that he was on all floors with his ass lubed, waiting for them. And then the ex-boyfriend would direct message with these strangers and use the geolocating function on Grindr to send these visitors to Matthew. And this didn't happen once, it didn't happen twice, it happened over 1,200 times. This wasn't online harassment. These people came in real life. They would wait for him outside his stairwell. They would follow him into the bathroom at work. They were there to rape him. And Matthew did what anybody would do. He went to the police station 10 times and filed police reports. He got an order of protection against his ex. Nothing would happen. And nothing changed it. And so Grindr was in the exclusive position to be able to stop this abusive user from using their platform. And they ignored over 50 requests from Matthew. They ignored a demand letter from me. They ignored a court order from the New York State Supreme Court. And when we finally got them to court, they said, Grindr, which has hundreds of millions of users all over the world, said that they didn't have the technology to exclude an abusive user. Now, their terms of service says that they have the discretion to exclude anybody who's abusing their platform, yet they didn't actually have the functional ability, so they said, to do that. Their competitors, much smaller companies, did. But our theory then was that, hey, if you have a hookup app that depends on geolocation, and you've not designed and created a product for the absolutely like foreseeable situation that sometimes it's going to be abused by predators and rapists and stalkers, you've not designed a feature to exclude those users or to even respond to victims, then you've created a dangerous product. And so we sued Grindr, not for any content that Matthew's ex posted, because that, of course, would be immune from liability. Grindr would be immune from liability for any content that his abuser posted, any words, anything on the profile. We didn't sue them for that. We sued them for under product liability theory. And of course, thinking that this was going to be the way to skirt around Section 230 because it wasn't based on third-party content. And our judge in the Southern District of New York dismissed it on a 12b6 motion. We didn't even get to go into discovery. That was upheld by the Second Circuit. And it basically expanded. In my opinion, it's the most extravagant interpretation of Section 230 in the, since it came into being in 1995, where, really, even if there's an immediate crisis that you're seeking court assistance with, even if you're not suing for third-party content, even if it's not a publication tort, still, on a 12b6 motion where Grindr didn't even have to plead that they were immune from liability under Section 230. They didn't even have to say that they were an or that they were being sued for a publication of third-party information content. It just shows that we have no rights against these behemoths. Something needs to give, okay? This isn't even a Zarin case. Zarin sued 9 months after the injury happened. This is like, there's no justice against big tech.
Yeah, thank you so much, Carrie. The Herrick v. Grindr case, I think, and I think I'm actually maybe an outlier among some of my cohorts who are very in favor of, or not in favor of any type of 230 reform, is that I think that Grindr case starts sits on the line, on a very important line between content and conduct, and service and platform, that I think it's potentially has been that 230 has weighted a little bit, that the shield that immunity that 230 provides kind of slowly weighs into. But Cathy, I want to get to you, and then we're kind of gonna go into more general questions and kind of like respond to each other and stuff. Cathy, do you have thoughts about kind of why we're talking about 230 and why we're talking about it now?
Yes, boy, do I have thoughts. Okay, so I think in terms of the why now, I'm somewhat perplexed by why it's coming up. Because there was this great policy balance that was struck when Section 230 was passed, which is we want the most good stuff online and the least bad stuff online. And I'm not entirely sure why we would have changed our mind and decided that's not the way to go. I think what's happening is this convergence of things. And basically, Section 230 worked. Section 230 worked. We got an internet, and the internet has allowed, for the first time in history, all 7 billion of us on Earth to interact with each other. The downside is all 7 billion people on Earth can now interact with each other, and we don't really know how to do it very well. And a lot of the pain points we keep feeling is what happens when we're not doing it very well. The reality is that some of the 7 billion people on the planet are terrible and want to say or do terrible things. And now we're sort of seeing that in a certain degree of volume, and we're upset about that volume. And we're not coping very well. So we're sort of having a very panicked response, and that's not unreasonable. But we're looking at, oh my gosh, bad things are happening. The internet seems to be delivering them. So hang on, let's have a gigantic timeout and let's figure out what's going on. The problem is that all the things that we want to push back on with the timeout and make changes are essentially using law to create an artificial technological scarcity. Because we're having some problems dealing with all 7 billion people talking to each other at once, what we're threatening to do is bring us back to a world where all 7 billion of us can't talk to each other. And I think that wouldn't actually be a good thing. It wouldn't solve the harms, and all it would end up doing is sort of preventing us from, because terrible people are still out there wanting to say and do terrible things, but it would take away our ability to come together and unite against these terrible things. So that's the basic point about, I think, why now. We're just sort of, having some growing pains as we deal with having a computer-mediated communication, modern life, interconnecting the entire world, and we need to sort of develop new tools, new norms, new social habits and recognitions to figure out how to cope with it. I think we can get there as long as we don't throw out the baby with the bathwater and revert us back artificially to a time before we had this technology that would enable these connections. Now, in terms of what's come up and why people are pushing back for it, I think we've got a couple of threads. One of the things that people don't like, and this gets to what David was talking about, are things that people don't like about the internet world that are really not objections to Section 230. They're really objections to the First Amendment and the type of editorial discretion that they afford platforms the same way that they would afford editorial discretion to any particular individual user. And I often make the analogy of okay, I guess most of us have Facebook accounts. I suppose some people don't, but you're familiar with it. You might have a Facebook account. And if you have a Facebook account and you've posted a picture of your kid, and somebody goes onto your picture and places a comment that says your kid is ugly, I mean, do you want to keep that comment up there? You probably want to be able to take it down. That's the sort of editorial discretion that the First Amendment would give you. Conversely, if somebody said your kid is awesome and great and the cutest one ever, you wouldn't want any sort of legal compunction to force you to have to take it down. You want that editorial independence. But so let's say now it's not a Facebook post where you're intermediating third-party expression on your posts. Now you have a blog, and your blog takes comments. And maybe now you've grown out of a blog, now maybe you're running a whole forum. The whole forum has user feedback and user comments. Maybe it's such a popular forum that you want to monetize it. Maybe you're running ads, maybe you're selling subscriptions. Now maybe you're a little bit bigger. You've gone into business with your friend, and now you want to make yourself like a corporate forum so you can manage the forum and make money and not have tax repercussions and things like that. And now your forum is so popular that you've monetized it, you've corporatized it, and now you want to IPO. I mean, the question that's raised is, at what point in your growth cycle between an individual who would be able to edit and control your Facebook comments have you now gotten so big and corporatized that you lose that editorial discretion? And I don't think that's supported in First Amendment law. So that pushes back against some of the conservative arguments, that I think what people are really objecting to is that ability to have editorial discretion. And unfortunately, if you don't like that, you really don't like the First Amendment, and that's a very different discussion than should we get rid of Section 230. But that goes into the other bit about what is the gist of Section 230, because it kind of embodies these First Amendment principles and makes them practical for companies to basically, especially if we go back to that policy balance, that we want the most good stuff and the least bad stuff. The simplicity is the point. We don't want people who are intermediating user expression to have to expend all their resources on lawyers. This is not efficient. This is not effective. It doesn't create a better user environment. It doesn't create a better user experience. It just is this gigantic drain on platforms. So the point of Section 230 was basically to take that First Amendment principles of, you get to have that editorial discretion about the user expression you're intermediating, make it something that's practical and sound so you can get about your business of continuing to be that forum without being, distracted and getting drained and all of a sudden then not being able to be available as a platform even for productive uses and productive user expression. I'll pause there just so we can keep going, but there's more.
Microphone again, Kate, I think.
God, thank you. I'm like outside, so I'm trying not to have the wind going, so I turn it off. So that was great. I think we have a nice kind of summary here of we have on the right and kind of on social conservative. And I do want to get back, Carrie, to your point about you are not necessarily the left, because I think that that's also correct. I wouldn't say the left, but I would say that people with more progressive ideals who are trying to kind of see and represent people that are harmed by things on the internet, in like particularly minorities and women, that kind of get a lot more of that type of abuse. And then you have people on the right who are concerned that social conservatives are being discriminated against through the rules that these platforms have made. I think that I want to kind of get to this idea in that Cathy kind of brings up about the First Amendment, right? And about how this was like an instrumental First Amendment for these platforms to use. Let's put out into this conversation that Section 230 does go away. There is a very good argument to be made that the First Amendment would simply honor platforms' own abilities to, and I know everyone's nodding their heads, which I can't believe I got something that we can all agree on, like, but that Section 230 goes away, and that the First Amendment is going to be this very robust, will be interpreted robustly, and basically the courts will have and give this same type of immunity to platforms that they might give to the New York Times or some other type of defamation is a hard thing to prove, honestly. Like this is not like, it's not like just anyone can sue like a publisher for anything. And so the thing about that is, and this happened earlier in the week, was that there was a conversation, I can't remember who said it, but it was around the idea, it was Tuesday. It was around the telecom and agencies conversation. And it was basically the idea that, but because of Section 230, we don't have any First Amendment doctrine really around how we should deal with platforms, because Section 230 steps in, which makes me think, and sorry to make this question so long, this prompt so long, but I'm really excited to hear what you guys have to say about it, which makes me think though that we're going to start over from square one. And is that a good thing? Maybe it is. I'm going to query that maybe it would be, because 1996 was a very long time ago, a very different internet, a very different whatever. And then maybe it's baby with the bathwater, as Cathy said. We've done all of this work of slowly creating this doctrine around Section 230 that takes the place of maybe where a First Amendment doctrine would be. And we're just going to have to start over from scratch. And it's a huge waste of time. David, thoughts about that?
So yeah, so many thoughts, but they'll be concise, I promise. First, I think it's absolutely the case that a version of Section 230 is mandated essentially the guts of 230 is mandated by the First Amendment. Not on all the particulars, not on all the details, but sort of the heart of 230, the guts of 230 is mandated by the First Amendment. And that's only been amplified by the fact that really First Amendment jurisprudence over the last 30 years, almost 30 years since the Communications Decency Act, has only become more robust. It's not like the First Amendment has been whittled away by the Supreme Court, usually by 7-2 majorities or strong cross-ideological majorities on the court have been really extending the boundaries of First Amendment jurisprudence. So I think a version of Section 230 would lock in through the First Amendment, which is something that I think a lot of critics of Section 230 are completely overlooking. But the getting from A to B would be messy. Okay, it would be very messy. There would be a blizzard of litigation. And the irony of it all is that big tech would muscle through it. And a lot of the smaller websites and the smaller platforms would immediately find themselves extremely vulnerable. You would see, I think, comment sections coming down at scale. You would begin to see a lot of smaller voices really limiting the amount of speech they allow on their platforms because they can't muscle through. They just don't have the resources. But you would, these giant tech companies, and Carrie very effectively described how wealthy and powerful that they are. That some of them are among the wealthiest corporations in the history of humanity, would be able to muscle through this and would be able to get from A to B in a very messy way, but that it would effectively give us some version of 230, especially in those areas of communication and speech that are the most controversial politically, where there's going to be a extreme reluctance of the Supreme Court to allow the government to regulate political speech, and that to the degree that many of the 230 critics hope that it would. And so I agree with you completely, and I think that perspective and that idea you just articulated is largely missing from the debate. And the other thing that I would say that is missing from the debate is that I think social conservatives in particular don't realize the secondary effects of 230 repeal. We've in a previous conversation talked about how it's almost like they should rename sort of 230 repeal or modification the Bring Porn to Facebook Act. Because if you're going to require these companies to sort of go all or nothing, you're going to see them become, do we want a world in which social media has to become more like Gab to maintain protections from liability for user speech? I don't think that's the world that people want. And so I think in the short term, 230 repeal would privilege the most powerful corporations. Over the medium term would result in something like 230 locking back in as a constitutional matter, and that especially social conservatives in the interim, be careful what you ask for.
Yeah. Carrie, I'm sure you have thoughts about that. I know that there is a lot to kind of cover, but in particular, do you kind of buy this idea of if Section 230 went away, we'd end up having more and more harms on the internet, kind of more, we would have an internet that we didn't really want? Or are you kind of, do you think that that's kind of a pretext that people use?
Well, I think the first maybe mistake that we're making is this idea that that folks who feel that individuals should have the right to sue the companies that harm them, that somehow they're enemies of the First Amendment. That's not true. Like my clients, and somebody asked for a trigger warning, so I'm giving you a trigger warning right now. I'm going to start talking about some of my cases. My clients are 11-year-olds who've been targeted on Instagram and then become sextorted and basically become the sex slaves of people who find them on Instagram. They're victims of child sexual abuse material. I have a client whose daughter was murdered by a serial sex predator on Tinder. Like, this is not speech, okay? demanding that companies share responsibility for the really extreme abuses that happen on platforms is not attacking speech. And no, I don't think that scaling back the immunity for tech companies is going to suddenly flood the world with litigation. Already, it's really hard to sue. You know, it's hard to find an attorney who wants to represent you. It's hard to you know, pay for that attorney or find an attorney who's willing to take your case contingency. If they're going to take it contingency, then you have to show that you've got a lot of damages. You have to, you know, under Iqbal Twombly, you have to have really, really strong pleadings. You have to show causation. The actual tort system already filters out the majority of crap cases, okay? And so this idea that there's going to be a flood of litigation is just wrong. There already would be a flood of litigation by all those people that don't even know about Section 230 if that was actually a threat. Most people don't want to create that, don't have the time or energy to actually pursue litigation unless there's been a really serious harm. So, you know, and also, like, what's your proof? Where's your data set? Prove to me that removing some of the immunity that tech companies have will flood the courts. We haven't had it. We haven't had that historically. We haven't had that situation happen in history. You know, like, the companies have had Section 230 for the majority of the time that, I mean, for all the time that the internet is the internet as we know it. So no one can actually say what would happen.
Yeah, I think that that's fair, but there's certainly some types of, possible outcomes that could happen. I'm going to flag this issue and we'll get back to it, but I want to hear from Cathy first. But I just wanted to kind of, I think that your cases really do end up centering, and I think bring up a really interesting point about 230 and its interpretation through the courts, in which it was really, that at the time in 1996 when it was drafted, that the thing that it was really speaking to were message boards and like kind of like these things that were very clearly speech. And now we have all of these apps and all of these types of things that are really performing more services and conduct. And like, I find that to be a more persuasive, potentially more persuasive kind of reason to reform Section 230. That being said, David's point about kind of the very, how do I put this? The incubator-like nature of Section 230 for smaller companies is, I think, especially important as we have these behemoths, these really large companies. So something I kind of want to put on the table and see what you think, Cathy, is like people have proposed creating Section 230 that once you get to a certain level of income, if you get into a certain level of revenues, once you get to a certain level of maybe employees of the company or users of your product, that Section 230 goes away because it does have that incubation kind of idea. What do you think about those types of ideas?
Well, as I was starting to say before, I think they're terrible. Also somewhat unprinciply tethered about the First Amendment doesn't have an expiration point. It applies to users, and it applies to individuals, and it applies when individuals get together with the rights of association, with business partners. That would be a pretty significant doctrinal shift in the First Amendment to read in some tipping point where it no longer really applied. But I think getting back to the question that started this round, starting with David, is like,
hold on just really quickly. That's not totally what I said. So I said like Section 230 wouldn't apply. And are you saying that Section 230 is the same as the First Amendment, full stop? Because like you could make, you know, Facebook like the New York Times, but then you could have smaller sites like Reddit, or, I mean, Reddit's pretty big too, but like, I don't know, like Joe Schmo's webpage would be like, I don't know, still be covered under Section 230 from civil liability.
Well, Josh Hawley's bill sort of tries to do that, where it talks about if you are this big, get this many users, have this much revenue, then all of a sudden it doesn't apply. But especially to the extent that Section 230 is operating so strongly on First Amendment rights, including the First Amendment rights of the platform, I think you have a hard time constitutionally justifying, like from an equal protection standpoint, about at what point do you no longer get that statutory benefit. That is, statutory benefit of applying First Amendment principles to the platform only goes to certain individuals in certain associations, and at a certain point you lose that. I think that's something that has some constitutional problems with it. I think you also go back to like that original question about like, if we had no Section 230, could we still have the internet? Would it get us to the same place? And I think the answer is theoretically maybe, but on a practical standpoint, no, it won't. And this also brings up what Carrie's point was about, well, would this really be so bad? And I think absolutely it would be so bad. And I think we've got some evidence for it. In terms of theoretically, you would still be left with two substantive doctrines to work with. One of which is all this First Amendment doctrine that we're talking about editorial discretion of platforms, plus the First Amendment rights that are built into the speech of users. Secondly, we've also got general principles of secondary liability, and there are some doctrines, and there's tensions within these doctrines, but there is the basic question of when do we hold a third party liable for somebody else's behavior? It does not necessarily tip to say that we do that all the time. We tend to do it under very limited circumstances, and there's some tension between states and courts about to what degree do we like to have those secondary accountability, but it is not straightforward that we necessarily have in our law or want to have in our law these direct connections. There's very important reasons of why we don't hold third parties accountable for other people's behavior. So, like, for instance, in the things that Carrie is talking about, I mean, she's describing really terrible behavior, and I would like to make sure that the people who commit these terrible acts are held accountable for the terrible acts. But I think also what she was talking about a platform might be seen as aiding and abetting these acts. I think that's a tricky argument to make, and there's a lot of reasons not to make it, because there are reasons why we don't want to hold third parties responsible for other people's behavior. It's not effective, there's collateral consequences, which we see play out in the 230 space, and ultimately that may not be the thing that's even most directly relevant to getting the remedy we need. If people have been hurt, we want to make sure there's laws that can deal with the action that hurt them. But that doesn't mean that going after the middleman is the way to do it, especially when going after the middleman will have these downsides.
Okay,
then,
so
yeah.
So I'm gonna jump in. So I do want to flag that Carrie actually does just agreed on something, which is basically that Carrie has, I think that when she said before that there was she said before that basically like, maybe the sky won't fall because tort liability is hard. And there's like a pretty high burden, as you said, the third party liability, in which we don't allow a lot of these things. So a lot of these claims would still not like land, even if we got rid of Section 230. I want to let David and then Carrie respond really quickly. But we have a question from Molly Land that is very good. And I wanted to read it really quickly. She asks, which I think is exactly on point with what we're talking about right now, platforms are in the best position to innovate to solve some of these problems of online harms. Wouldn't making them liable for at least some of these harms encourage and incentivize them to innovate to address these harms? Carrie is dancing in the background, but David, you go first and then we can get to Carrie.
Yeah, so I think when we're talking about Section 230, I would agree to a limited extent with Carrie that Section 230 shouldn't be seen as a blanket immunity from liability for everything that happens online with these platforms. It's not written that way. There are still, there's still such a thing as breach of contract. I could even see certain circumstances where a product liability analysis would lock into play. I think that we often overestimate how different the online world is from the real world. So for example, let's look at product liability. Here are some really huge, powerful companies, car companies. They have extremely deep pockets. Well, sometimes they're almost bankrupt, but as a general matter, they have extremely deep pockets. But they're not liable for the damage every time there is a car accident. There'll be these terrible events that occur, and awful things happen to people. Tens of thousands of people die every year on the roads, and hundreds, 1,000 plus are injured. Terrible, terrible stories. But Ford is not liable for every amount of damage when someone is hit with a Ford Explorer or a Ford F-150. They're liable when there is a product defect, if the brake fails, if the if there is a failure in the design and performance of certain safety provisions, et cetera. And so we do have structures that say that when somebody when harm is done through a product or using a product, it does not automatically equate that liability attaches to the maker of the product. And we've got decades of authority on that, decades in the product liability arena. Some of that I think can be applicable online. Now, the speech arena is, we also have decades of authority on things like who is speaking, who is liable for speech. And that's why I think that, and I might disagree a little bit with Cathy on this, is that's why I think the First Amendment is largely going to get us to a version of a Section 230 because of these questions, like who is speaking. If I write and I post something on a Facebook comment board and it pops up immediately, there's been no intermediary editing at all, and it's there, that's my speech. That is not Facebook speech, and it doesn't become Facebook speech if the fact that in a previous comment that I put, I violated Facebook community standards and they deleted it. That does not suddenly make me Facebook by sort of any common sense version of, or any common sense or First Amendment precedent, that the fact that someone has previously controlled my speech makes them, the controller, also the speaker the next time I speak. And I think that that's one of the things that I think that critics of 230 are just completely missing. The argument that the fact that you might cut off my mouth, going back to the thing that the original example that I gave, cutting off my mic if I'm ranting at a town council doesn't suddenly make the town council me for purposes of free speech litigation. If I'm a professor in a classroom and a student starts to rant, and the professor doesn't have he's not all of a sudden locked into this binary option that either I let the student rant to separate the two of that, make sure that it's only the student speaking, or if I put limits on classroom conduct, then all of a sudden I'm responsible for all my student speech. These are the kinds of binaries that, I know you probably dealt with this extensively in the history of Section 230. You had this CompuServe and the Prodigy cases that put this weird all or nothing dynamic in place. And from that standpoint, it was back, arguably this is back when Congress could actually legislate. They stepped in and put in place a structure that's the structure that the courts would probably closely get to after 8 years of litigation. And I think that people who want to yank that away are going to find years later that we're at largely the same place, and years later in a process that has privileged more powerful voices in the interim.
Yeah, Carrie, do you want to respond?
Yeah, I agree with a lot of what David just said. And I was told before this panel to be nice to him because he's a very nice man. But it's actually easy, because I agree with him, which I'm a little surprised about. But I think, one thing I wanted to say, to add on to what David said in response to something Cathy said, is that we actually do hold third parties responsible for behavior all the time. I have a lot of cases against schools where there've been Title IX violations, and schools have been deliberately indifferent to dangerous situations. And I have cases against employers, same story. Cases against landlords where they've allowed injurious and dangerous conditions to continue on their properties. It's not unusual for third parties to be held responsible when they are being deliberately indifferent, or when their head is in the sand and they're refusing to see or hear things that happen on their watch. And, particularly in situations where, these companies are minting money, to use a term that Eric and Johnstone says, they're minting money off their users. Why should they have no responsibility to their users? But also, we're not just talking about suing them for third-party conduct or content. I'm suing them for their own BS, like in the child sexual abuse material. These companies are the ones in possession. I'm not suing them just because somebody else posted and distributed child abuse material. I'm suing them because this material is actually in possession on the servers that these companies own. And that is illegal. I'm not actually suing them right now, but it's like, I want to. So, let's actually be thinking about their own role in this. And we really didn't have the same sort of issue and distribution mechanism when it came to child pornography before the internet. And the companies, and our mainstream companies like Facebook and Amazon servers and even Dropbox, they're the main perpetrators of dissemination of child pornography. That didn't exist. Those channels of getting the material and distributing it didn't exist before the internet. And yet these companies have no incentive, as Molly pointed out. They have the only companies that, the only entities that actually should be pressured to cure the situation are just lazy as all hell because they don't have the incentive mechanism. This isn't just about, hey, let's sue as much as we can. It's about the threat of lawsuits. The threat itself makes companies more responsible. And not just about, content moderation, which I agree is completely a First Amendment issue and would be protected even with changes to Section 230. Facebook could say we no longer want any posts to have the letter T in it, and that would be their First Amendment right. Let them keep moderating their content however they want. But this, it's different when we're talking about the things that go beyond just content moderation and really are more conduct based.
Cathy, I'm sure you have something to say in response to that.
Yeah. I think we need to go back to the core of what 230 is trying to accomplish. We've got companion goals that need to be maintained at the same time. We want the most good stuff online and the least bad. And what starts to happen is when we try to skew and create the risk of litigation for platforms, we end up dropping the ball actually on both of them. We have to keep both of these balls up in the air. And this is what I was referring to about, yes, we have some practical data about what does happen when we start stripping platforms of Section 230 protection. We have seen the cost, particularly to the keeping the most good stuff online ball landing. For example, with FOSTA, we are now starting to see, actually, and we started to see it right away because there were so many issues with how the law was articulated, we started to see a lot of censorship. We started to see a lot of lawful content being taken down by platforms terrified about the potential liability if they left it up. That was a hit. That was a cost. That meant that we were losing on the keeping the good stuff up on the internet. Then we have the whole IP exemption from Section 230, which means that if there's an allegation that the thing wrong with the speech is that it violates copyright, that starts taking a hit and coming down. And this is why the internet looks like Swiss cheese all the time, because we're instead using the DMCA, which does provide some protection for platforms, but in such a conditional, complicated way that platforms basically, if they see the allegation that the user's speech is potentially infringing, they have to delete first, and that's the end of it. We'll never get to a point to even really figure out whether that speech was in fact unlawful at all. The censorship has now happened. And again, we've dropped the ball on the keeping the most good stuff up on the internet. So the problem when we start to focus on, well, let's strip immunity to make platforms do a better job about getting rid of the bad stuff, it doesn't end up working. From a practical standpoint, A, we have two objectives, and B, we are better off at achieving both of them when we go with, and the word incentive keeps getting bandied around, and I think that's right, I sometimes describe Section 230 as all carrot, no stick. We have these two goals. We want the most good stuff and the least bad stuff. So what do we need to do to make platforms the most effective partners in achieving both? And scaring them with punitive consequences doesn't actually get us there. It tends to compromise at least one of those values, and it isn't effective because we end up draining their resources away from effective moderation, effective design, effective engineering, and instead paying lawyers. And I'm a lawyer, I like getting paid, but really that shouldn't be winning in this situation. This should be something where we are leaving the platforms in the best position to cope with the challenges that they're facing by what does it mean to intermediate all this user expression. And one other thing I want to throw out, and we can get back to it, but one of the things that's important to remember is that Section 230 is not just about defamation. It's about all forms of liability that may be manifest in user expression. And one of the things that I think we lose in some of these debates and discussions and even some of these litigation cases is the nexus of platforms and speech. And that a lot of what we're looking at in terms of when we're unhappy about something that is resolved from an internet service being used in an unfortunate way is still connected to speech. And I think that, you know, when we get into the discussion about secondary liability principles, that's really important because the whole idea of why we think the platform should be liable is because at its core, it facilitated user expression. It's user expression if somebody posts a tweet, but it's also user expression if somebody posts a Craigslist ad saying, I have something to sell. It's user expression if somebody posts an Airbnb listing, which basically is expression saying, hi, I have a home to rent. All of these things that we're looking to impose liability on the platforms do ultimately have a nexus with speech, and that speech could be unlawful or allegedly unlawful in a number of ways that has nothing to do with defamation. Section 230 was never drafted and never intended to be such a specific use case. It wanted to cover all forms of user expression and all forms of liability that could potentially make this user expression wrongful, with the exception of intellectual property problems. And I think that as we
and federal criminal law.
And federal criminal law. If the thing that was wrong with the speech is that it violated federal criminal law or intellectual property right, Section 230 had no value. But ultimately, otherwise, the whole point of what is whoever imbued the unlawful quality in the speech is liable for it, but not the platform that facilitated it. And that's the core thing I think we always need to focus on, even when we look at these more complex examples as the internet has evolved.
Yep, I think that that's a fair. David, do you want to respond to that? I also kind of want to point out that you have a particularly interesting story, David. I don't know if it's up to you if you want to share it, but I know that you have been the victim of a lot of abuse from online places. You've written about it openly. We don't need to necessarily get into it, but I do think that like you kind of bridge this interesting world in which you are an advocate for free speech and an advocate for the First Amendment, and yet you have seen some of the worst kind of behavior that the internet has to kind of has to offer.
Yeah.
And so I would love it if you could talk about that a little bit.
Yeah, I mean, so starting in 2015, after I began to be strongly critical of Donald Trump and some of his then foremost supporters like Ann Coulter, the alt-right came after our family in a very vicious way, starting on Twitter, and then it leaked into real world threats and all this. But on Twitter, it was grotesque. Took the pictures of my daughter, my youngest daughter, who's African-American. We adopted her from Ethiopia, took pictures of her and photoshopped her face into gas chambers with Donald Trump in a photoshopped SS uniform, gonna press the button, photoshopped her face into slave fields. Horrifying stuff. And it then leaked into comment sections on my wife's blog. She wrote for a religious website, and they just filled comment section of my wife's blog with images, horrible images of dead and dying African Americans. It was a terrifying experience. And we took full advantage of blocking, reporting, notifying law enforcement. And it took a long time. It took months before we really felt like we had a handle on it. And, so one of the things that I think that I like the way Cathy frames this. She says, we want more of the good stuff and less of the bad stuff. And there were existing tools that were in place and in some ways empowered by 230, the good faith moderation of objectionable content that really helped protect us over time. It took time. It was painful. It was awful, but it really did help protect us from the worst of the online stuff. Now, when you got offline, that was a whole other issue dealing with law enforcement. But, and so, yeah, at the same time, I look at that and I thought overall, in a weird way, the system worked. It worked slowly and painfully, but overall the system worked. And Twitter didn't want to be the kind of community that hosted that kind of content directed at any of its users, whether they were for or against President Trump. And so it should have the right to do that. It should have the right to do that. And one of the things, without being held liable, because they're knocking down and removing posts that have a picture of a 7-year-old in a gas chamber. Like the idea that they're moderating, and that would be constitutionally, arguably constitutionally protected imagery. The pictures of my 7-year-old were taken from public sources, and it probably wouldn't be construed as a true threat. I mean, so arguably that was constitutionally protected expression taken down by a private actor. And the idea that somehow makes Twitter liable, that it becomes then a publisher and not a platform. And we could spend all day talking about how anybody that's a whole other discussion, that if you're saying that if you moderate, all of a sudden you're a publisher, not a platform, that's so absurd. But so in that circumstance, it took time, it was painful, but the less bad, more good principle that Cathy has been talking about played out. One other thing, though, that I think it's important to address, if you talk to people about what's wrong with big tech, it's really becoming clear in this conversation that we have such different buckets of concern. So there's one bucket of concern that is kind of just located in negative partisanship. Big tech is empowering people I really don't like. And that's a lot of the anger at Facebook right now from the left, is that conservative publishers dominate Facebook. And there's a lot of fake news and sort of marginal sites that get a lot of purchase on Facebook. And so there's the negative partisanship that says these people I don't like are very empowered by this website. And that's one kind. Then there's another bucket that says, well, what I really want is to be just treated the same. I don't want to be in a website where one point of view or another point of view is being privileged. And these are sort of like what you're calling the more pure political speech concerns that are arising in negative partisanship. Then there's this other bucket that Carrie's in, that is horrible things are happening to human beings irrespective of ideology. And they're happening in part through the technology that exists in big tech. Whether you're left or you're right, whether you dislike, love or hate Ben Shapiro or love or hate Huffington Post, nobody wants to see children objectified on these platforms. And what do we do about that? And it feels like that's a kind of a separate bucket, but to just make it all more complex, as Cathy gets at, it all comes back, a lot of that comes back to speech interests as well. And so we have this incredibly difficult challenge that I think is never going to be fully solved. And I think we just have to get comfortable with we'll never fully solve it, because we're dealing with human beings at scale. And you're never going to get to where you exactly want to be.
I think that this is thank you for that. By the way, if anyone hasn't been watching for the last hour, David just summed it all up in basically 3 minutes. That was very succinct. Well done. Please do put your questions in the Q&A, but I want to respond to what you said, David, because I think you're exactly right. These are issues that what's really weird, and Dave Wilner said this yesterday. He was, who's, former head of content for Facebook. And he was just kind of like, why do we think that because we're typing into this computer that all of these issues should be resolved by this computer? That there isn't like this, that this isn't just made by humans and done by humans, and this isn't just the same types of problems that we've had for time and memoriam of people being crappy to each other and doing things. But to Cathy's point, and to something you just said, David, that I think was great, here's the thing that makes this particularly difficult to kind of put it in like doctrinal, like First Amendment terms, because that's kind of the language I come from. Everything that you do online has to come through speech, because it is an interface of speech. And so that is why the matchmaking service of Grindr looks like speech. Like, it wouldn't have been a question if if Carrie's client, Matthew Herrick, had or her boyfriend had gone and posed as Matthew Herrick and had walked into an office like a gay matchmaking service named Grindr and given them a profile, and they had then distributed that profile to everyone in their network, you could clearly sue. That matchmaking service, that would be so obvious. But the difficulty here is that Grindr has this valence of speech to it, that you're putting up these ads and putting up these posts. And so why isn't this speech? But that's just the very nature of interacting with computer services. They have to be put into speech. And so this is why I think that this line is very, very hard to draw. And that's a line, by the way, that the First Amendment has always struggled with and never gotten right. If you're Justice Kennedy, you think everything is speech. If you're not, you're anyone else, you think there are limits. If you're Bork, you think it's you think that basically only, talking about electoral politics is speech. But there's this is kind of the difficulty that we're trying to straddle. And I think that you put it really well, David. And I just do want to kind of point out, though, that as much as the internet is a recapitulation of real life online, that's the difficulty. It's a recapitulation that turns everything from conduct to commercial speech to whatever, just into speech, just speech. And so that's why we're kind of in this dilemma, and why I don't think we'll ever have a solution for it. I'm going to go to Jenny Stefanati. She has a really great question. Jenny, you were should be I
think I'm unmuted.
Okay, great.
Yeah,
go ahead and ask your question.
Yeah, I was wondering what you guys think about amendments to 230 in light of what is a new form of content moderation that emerged with Twitter's labeling of Trump's tweets. Because I think if you look at C1, that's basically saying, as an intermediary, you're just propagating user-driven content and you're not responsible for it. And then C2 says, if you want to take something down, that's okay. But there's nothing in 230 right now that looks at if you're actually amending that content in some way, which to me would seem to be an editorial act that makes these platforms, at least for that subset of posts, look more like a publisher. And I don't know if that then kind of gets us to the situation you were articulating earlier, if you got rid of 230, then you'd be back against the First Amendment and you'd have litigation that would just get us to where we are now. But I'm just wondering, what you think about this kind of new content moderation tool and the implications for that, for the protections afforded by 230 as it currently is written.
Yeah, great question, Jenny. Thank you for asking it. Cathy, do you want to go?
It's a question that comes up a lot. And this is that horrible publisher platform nonsense that comes up. That's not meaningful for purposes of Section 230. What Section 230 ultimately comes down to is who imbued the potentially wrongful quality of the speech in question. If it was the user, the liability is all on the user. If it was the platform, then the platform may have liability and 230 won't matter for them. Now, we can quibble around the edges, and there's a lot of cases that do, but previous cases have made it pretty clear that you can have a lot of editorial interaction with that speech and still retain your Section 230 immunity. That really the question does come down to who imbued it with the wrongful quality that's now, at issue to be litigated over or something like that. And we see that even from some of the court cases, like roommates.com was one of the first cases where that kind of like split the baby a little bit, where people could post classified ads that could express racial discriminatory preferences. And the way that the court resolved it is to say you still retain the Section 230 protection for giving them the text box where they could say whatever they wanted, including hateful, mean things, without running into potential liability for housing discrimination. But when you prompted them to say, hey, how would you like to discriminate today in your ad, then they construed a certain authorship to think that the wrongful quality of that content you would actually be responsible for. Now, a footnote to that is it turns out that after they litigated this case for several more years, it turns out that in the roommates context, you're actually allowed to be discriminatory because of the First Amendment rights of association. So there was a whole lot of litigation that this poor startup platform had to go through to ultimately be exonerated for not actually having created unlawful content in the first place. And that's why Section 230 is so important, because we don't want to drain companies into oblivion to go through the process of finding out that they weren't liable at all. But in terms of the question, yeah, it's fine. You can do a lot of editorial interaction, and courts have not struggled with that before.
Okay, so just to sum up, so your response was, and I agree with you, like kind of under roommates and the progeny, that there's like all of the editing and labels for misinformation, et cetera, that the editorializing that Twitter has been doing would be fine under Section 230 without removing liability or removing
because
immunity.
you may be liable for whatever commentary you've added, like whatever text you've added. If that text happens to have its own legal problems to it, Twitter created that, they're on the hook, but it doesn't shape their liability in connection with the content that they're commenting on.
Great. Thanks. Carrie, go ahead.
I agree with most of what Cathy said, but we also have to think that anytime we're talking about the removal of liability, we're talking about, okay, is there a right to sue? But for every lawsuit, you need a cause of action. So I don't know what the cause of action would be for somebody to sue Twitter for them putting a flag or warning. So we have to remember that this just isn't just about content moderation and removal of liability. You still actually have to have the cause of action. So
no, I think that's a great point.
Be practical about this. We're talking, this is all about courtroom, like actual real life lawsuits. You can't just sue because you want to sue. You have to have a cause of action.
I think that's a really important point and totally meaningful. I think one of the issues are we see a lot of extraneous churn where people throw garbage through the court system. I mean, the First Amendment also includes a right of petition. So in some ways that's actually, by design. And the issue is, do we drain off the resources of these platforms too easily so that they're denied their ability to actually be effective platforms and be better platforms because they have to fend off frivolous litigation? So you're right, the case wouldn't go forward and ultimately they wouldn't be felt liable and have damages. But like with that roommates example, they had to litigate the crap out of it for 6 years and spend a hell of a lot of money on lawyers when it turned out that they weren't liable at all in the first place.
Yeah, go ahead, David.
Yeah, one quick point on this. When we're talking about this very issue, this is one of the side effects of, and I'm not saying this about the questioner at all. I think the question was really, really good. The discussion of publisher platform has been distorted by, I would say, the largest amount of intentional legal misinformation I have ever seen in my life in a public debate. And that is this idea that Section 230 was designed from the ground up to guarantee neutrality and access of all voices, and that there is a binary state of being between publisher and platform. And that as soon as you start doing one thing, you switch. It's like going from Democrat to Republican, or going from the Celtics to the Lakers. You're just changing identities. If you moderate too much, there's a line. Like if you moderate too much on Twitter, all of a sudden, all of Twitter is a publisher. When the reality is, let's just take an example to talk about Carrie's, where is the cause of action? I could imagine a cause of action against Twitter for publishing Twitter speech. Let's take a fantastical example. Let's say that Twitter does another fact check of Donald Trump. Okay, Donald Trump says, I am innocent of any crime. And then Twitter has the little exclamation point. You click on it and says, actually, Donald Trump was convicted of holding up a gas station in Queens in 1974. Well, that would be defamation. And that's Twitter's speech. That fact check itself is Twitter's speech. And Donald Trump could march into court and sue Twitter. And if he could beat the New York Times, meet the New York Times v. Sullivan standard, et cetera, he could win. But that doesn't turn Twitter into a publisher for all purposes, so that every single ridiculous tweet that somebody makes, Twitter is liable for. And that notion that a entity can be a publisher while also being a Section 230 protected entity in certain aspects of its existence. Let's take my own website, our startup, thedispatch.com. Go to it. We have editorial comment and we have a comment board. We are not a publisher of that comment board, but we are a publisher of the editorial content that we put up, my newsletters that I write, the articles that are edited and posted on the website. And so you hear all of this stuff. You can't be a publisher and a platform. Yes, you can. If you do too much moderate, you have to be neutral. No, you don't. So I just wanted to, this is my mandatory 150-second rant about the disinformation that's out there that has so polluted this debate. And if you doubt it, go say something about Section 230 on your own Twitter feed and watch what happens.
Yeah, that was that was great. I'm gonna go. Carrie, do you have anything to follow up? Or are you good? Or anyone else? Okay, so you're good. Okay. That counts as speech, Carrie. This is speech. Anyway, okay, we have time for one last question. Danielle Blunt, please close us out before we wrap up.
Great. Can you hear me?
Yep.
Okay, great. Thanks. So I was curious about how you sort of see the upcoming carve-out attempts to CDA 230 fitting into a larger ecosystem of censorship and anti-encryption attempts, with the Lawful Access to Encrypted Data Act and the PACT Act, and just sort of everything that's been happening around CDA 230 and censorship in the last week. And I was also interested in if folks could talk about the impact that FOSTA has had on marginalized communities and chilling of speech, and the impact that further carve-outs could have.
Okay, I'm gonna head off the SESTA FOSTA thing to say that we are going to actively cover that tomorrow. So come back tomorrow, Danielle. We're going to have a sex worker advocate and sex worker and Kendra Albert from Berkman Klein Center at Harvard to talk about that alongside Cory Doctorow and one of the founders of EFF, and Daphne Keller, who is one of the early deputy general counsel at Google. But to the rest of your question, I think it's a great one. I kind of tried to start off with the PACT Act, but that is a terrible name. But I think that we needed to kind of cover some ground, and I think we did it perfectly. So yeah, let's come back to it. Do people think any of the carve-outs, let's talk, maybe we'll put the EO, Hawley's bill, and PACT Act on the table, have various types of benefits, things that are really just terrible, things that are maybe okay, things that are, that we're thinking might be good. Cathy, you want to start?
I think it's all irredeemable. I could stop there, but I can expound. The core policy behind Section 230, we want the most good stuff and the least bad stuff without diverting resources in ways that are going to compromise being able to best achieve both of these values. Every single proposal ends up undermining the achievement of that policy goal. I don't see any way we're splitting the hairs, or any way that the hairs can be split. I point back to the example of not just FOSTA, but the DMCA, and see what consequences happen to the keeping the most good speech up value when you start stripping these protections or make them complicated and conditional. It's not good. It's not a good picture. And I think that policymakers need to be a little bit more intellectually honest about what they're trying to do. Do they want to abandon this policy principle of the most good stuff and the least bad stuff? If yes, let's figure out what the new policy is going to be and build a law around it. But if the answer is no, then none of these things are going to be good, because they're all going to cause tremendous damage to our ability to achieve it. And it does not take a very significant change to any amount of this text of Section 230 to cause tremendous destruction. Just the IP exemption is like 4 words or so, and all of a sudden a ton of speech ends up taking a hit. It's not good. I just want to flag the anti-encryption stuff. That is problematic on its own. I think politically this is getting misused. It's kind of like different people with different political agendas have gotten together to sort of like, the people who didn't like 230 got together with the people who didn't like encryption, and now they formed this terrible Voltron of policy violence against all these values. But there's a bunch of counter-prevailing things: Fourth Amendment rights, First Amendment rights to anonymity, and basic math and policy and security. This is all a mess.
I will just say that I agree with that, and then I would add just that, like, it is a lofty goal to ask for more intellectual honesty from our.
I'm an idealist.
Yes, from our like current political environment, but maybe any political environment. Carrie, do you want to go next?
I agree with Cathy. It's absolutely all been irredeemable. But for the opposite reasons that Cathy's saying. I look at every one of these proposed bills to see if my clients who've been harmed in outrageous ways, like really extreme ways that go way beyond just content moderation, will they have a cause of action? Can they hold accountable the platforms? Will there be pressure on the platforms to innovate safely? And none of the proposed bills have met my litmus test. One other thing I want to add, just because I think we're probably wrapping up, is that we talk a lot about how Section 230 will create liability and suddenly all our platforms will be liable. But no, that's not what removing Section 230 would be. Section 230 just removes immunity from liability. It doesn't make our platforms liable for all the stuff that's on them. It just means that they don't have this big shield so that they can never be held liable. You have to still create the argument for liability in every single situation.
Yeah, I think that's a great point. David, do you want to close us out? Last word?
Sure. Let me close out with some piling on to the Trump executive order. And I just got to shout out to Cathy. Any Section 230 discussion that can include a reference to Voltron I'm here for that. So, this one, what I think is pernicious about the Trump executive order, and for those who don't know sort of its broad, we don't need to walk through all of its broad provisions, but he's essentially ordering rulemaking to through the executive branch, redefine and reinterpret Section 230, aiming at the good faith moderation provision, essentially trying to create a forum where you can challenge Twitter's good faith and its moderation according to a definition of good faith constructed by the Trump administration. I'm not sure about y'all. I'm not necessarily interested in the Trump administration's definition of good faith starting to govern speech online. And I'm, for that matter, not interested in the next administration's definition of good faith to be governing speech online. And then there is another interesting part of this. He asks friendly attorneys general to get involved in the effort to regulate social media, political speech online, including by having them study such things as algorithms, and other sort of, underneath the hood aspects of social media companies or other, internet companies. And again, is this what we want? Do we want state attorneys general who are often extremely ambitious politicians as opposed to sort of detached scholars of the law, lifting up the hood on our internet service providers to determine if they're going to meet what the attorneys general then determine are their standards, whether there's unfair or deceptive trade practices. Again, this is a giant invitation to get the various executive branches, the governors, the attorneys general, part of the executive branches of state governments, the presidents, the executive branch of the federal government, to get involved into large-scale speech regulation without even congressional intervention at all. This is outside of the statutory lawmaking process. And I find that to be at least the Hawley bill, at least some of these other Section 230 carve-outs are trying to go through the actual lawmaking process. The Trump executive order is attempting to circumvent all of that. Now, I don't think it's actually going to end up doing much, but the extent to which we continue to move towards executive authority to try to deal with, in particular, a speech question, I think is dangerous, and it's dangerous when we have political movements in the United States demanding such action.
Yeah, well said. Thank you all for coming. This has been awesome. I was really hoping that we could get down into the weeds about some of our disagreements. I think we did that really well and succinctly, and we're kind of able to flesh out a lot of really great thoughts about. Honestly, I think we stayed pretty much on point, like why it is that everyone's talking about this right now, and how all of the understandings of what Section 230 is by different parties kind of impacts why it's in the news and why it's coming up so often. We're going to end. I wanted to just say that you should come back for our last series, our last webinar of the series tomorrow with Cory Doctorow of EFF and Boing Boing, Daphne Keller, who's director of the program on platform regulation at Stanford Cyber Policy Center, Kendra Albert, lawyer at Harvard Law School Cyber Law Clinic, and Lorelei Lee, who's a writer and a sex work advocate. And we will be discussing imagining a world without 230, kind of starting first with SESTA and FOSTA and what that has meant for an industry that had depended upon Section 230 for some of its ability to function, and what happened following that, and then kind of broadening it from there. I think it's going to be really fun. We have not posted these episodes live yet, mostly because I am the only one doing this, and I am freaking exhausted at the end of every one of these sessions, and so I've not been able to download them and edit them so I can put them up online. But that will be happening soon, and it will be available on Lawfare. It will be turned into a podcast, and it is going to be up on the Yale ISP website. Thank you guys so much for a great conversation. I really enjoyed it. See you guys soon.